4. Continues in full force and effect without resorting to strike or lockout all the terms and conditions of the existing contract for a period of 60 days after such notice is given, or until the expiration date of such contract, whichever occurs later. The duties imposed upon employers, employees, and labor organizations by paragraphs 2, 3, and 4 shall become inapplicable upon an intervening certification of the board under which the labor organization or individual which is a party to the contract has been superseded as, or ceased to be the representative of the employee subject to the provisions of Section 9(a). And the duties so imposed shall not be construed as requiring either party to discuss or agree to any modification of the terms and conditions contained in a contract for a fixed period, if such modification is to become effective before such terms and conditions can be reopened under the provisions of the contract. Any employee who engages in a strike within any notice period specified in this subsection, or who engages in any strike within the appropriate period specified in subsection G of this section, shall lose his status as an employee of the employer engaged in the particular labor dispute, for the purposes of Sections 8, 9, and 10 of this Act, but such loss of status for such employee shall terminate if and when he is re-employed by such employer. Whenever the collective bargaining involves employees of a healthcare institution, the provisions of this Section 8(d) shall be modified as follows. A. The notice of Section 8(d)(1) shall be 90 days. The notice of Section 8(d)(3) shall be 60 days, and the contract period of Section 8(d)(4) shall be 90 days. B. Where the bargaining is for an initial agreement following certification or recognition, at least 30 days' notice of the existence of a dispute shall be given by the labor organization to the agency set forth in Section 8(d)(3). C. After notice is given to the Federal Mediation and Conciliation Service, under either Clause A or B of this sentence, the service shall promptly communicate with the parties and use its best efforts by mediation and conciliation to bring them to agreement. The parties shall participate fully and promptly in such meetings as may be undertaken by the service for the purpose of aiding in a settlement of the dispute. Public Law 93-360, July 26, 1974. 88 Statute 395 amended the last sentence of Section 8(d) by striking the words "the 60-day" and inserting the words "any notice," and by inserting before the words "shall lose" the phrase "or who engages in any strike within the appropriate period specified in subsection G of this section." It also amended the end of paragraph Section 8(d) by adding a new sentence whenever the collective bargaining aiding in a settlement of the dispute. E. It shall be an unfair labor practice for any labor organization and any employer to enter into any contract or agreement, express or implied, whereby such employer ceases or refrains, or agrees to cease or refrain from handling, using, selling, transporting, or otherwise dealing in any of the products of any other employer, or cease doing business with any other person, and any contract or agreement entered into heretofore or hereafter containing such an agreement shall be to such extent unenforceable and void, provided that nothing in this subsection E shall apply to an agreement between a labor organization and an employer in the construction industry relating to the contracting or subcontracting of work to be done at the site of the construction, alteration, painting, or repair of a building, structure, or other work, provided further that, for the purposes of this subsection E and Section 8(b) 4(b), the terms "any employer," "any person engaged in commerce," or "an industry affecting commerce," and "any person" when used in relation to the terms "any other producer, processor, or manufacturer," "any other employer," or "any other person" shall not include persons in the relation of a jobber, manufacturer, contractor, or subcontractor working on the goods or premises of the jobber or manufacturer, or performing parts of an integrated process of production in the apparel and clothing industry, provided further that nothing in this Act shall prohibit the enforcement of any agreement which is within the foregoing exception. F. It shall not be an unfair labor practice under subsections A and B of this section for an employer engaged primarily in the building and construction industry to make an agreement governing employees engaged, or who, upon their employment, will be engaged in the building and construction industry with a labor organization of which building and construction employees are members, not established, maintained, or assisted by any action defined in Section 8A of this Act as an unfair labor practice, because 1. The majority status of such labor organization has not been established under the provisions of Section 9 of this Act prior to the making of such agreement, or 2. Such agreement requires as a condition of employment membership in such labor organization after the 7th day following the beginning of such employment or the effective date of the agreement, whichever is later. Or 3. Such agreement requires the employer to notify such labor organization of opportunities for employment with such employer, or give such labor organization an opportunity to refer qualified applicants for such employment, or 4. Such agreement specifies minimum training or experience qualifications for employment, or provides for priority and opportunities for employment based upon length of service with such employer in the industry or in the particular geographical area, provided that nothing in this subsection shall set aside the final proviso to Section 8A(3) of this Act, provided further that any agreement which would be invalid but for Clause 1 of this subsection shall not be a bar to a petition filed pursuant to Section 9(c) or 9(e)(g) a labor organization before engaging in any strike, picketing, or other concerted refusal to work at any healthcare institution shall, not less than 10 days prior to such action, notify the institution in writing and the Federal Mediation and Conciliation Service of that intention, except that in the case of bargaining for an initial agreement following certification or recognition, the notice required by the subsection shall not be given until the expiration of the period specified in Clause B of the last sentence of Section 8D of this Act. The notice shall state the date and time that such action will commence. The notice, once given, may be extended by the written agreement of both parties. Public Law 93-360, July 26, 1974, 88 Statute 396, added subsection G. Representatives and elections. Section 9A. Representatives designated or selected for the purposes of collective bargaining by the majority of the employees in a unit appropriate for such purposes shall be the exclusive representatives of all the employees in such unit for the purposes of collective bargaining in respect to rates of pay, wages, hours of employment, or other conditions of employment, provided that any individual employee or a group of employees shall have the right at any time to present grievances to their employer and to have such grievances adjusted without the intervention of the bargaining representative, as long as the adjustment is not inconsistent with the terms of a collective bargaining contract or agreement then in effect, provided further that the bargaining representative has been given opportunity to be present at such adjustment. B. The board shall decide in each case whether, in order to assure to employees the fullest freedom in exercising the rights guaranteed by this Act, the unit appropriate for the purposes of collective bargaining shall be the employer unit, craft unit, plant unit, or subdivision thereof, provided that the board shall not 1. Decide that any unit is appropriate for such purposes if such unit includes both professional employees and employees who are not professional employees, unless a majority of such professional employees vote for inclusion in such unit. Or 2. Decide that any craft unit is inappropriate for such purposes on the ground that a different unit has been established by a prior board determination, unless a majority of the employees in the proposed craft unit votes against separate representation. Or 3. Decide that any unit is appropriate for such purposes if it includes, together with other employees, any individual employed as a guard to enforce against employees and other persons rules to protect property of the employer, or to protect the safety of persons on the employer's premises, but no labor organization shall be certified as the representative of employees in a bargaining unit of guards if such organization admits to membership or is affiliated directly or indirectly with an organization which admits to membership employees other than guards.